recommendation would be appropriate to include.
Would you accept that friendly amendment?
Well, my suggestion is we take that up with number 2, which, number 2, I'll just go ahead and read it. In addition, that the comptroller by rule, if possible, or the legislature by statute if necessary, prospectively further require all company holders to report the survey name and general land office abstract number from Railroad Commission Form W1, which is entitled Application for Permit to Drill, Deepen, Plug Back, or Re-enter. It's item 10, location on current form, for each well for which mineral proceeds are paid to the comptroller. And you'll see I've also submitted copies of a couple of W1 forms. Every well drilled in the state of Texas, the operator will file this form W1, this application to drill, which will have identification information concerning the survey where the well is drilled and the Railroad Commission, the GLO abstract number. I've included 2 samples that will, the application will include the form itself, a plat, and I've given 2 samples. One is from an operator, Carrizo Oil and Gas, that's more recent in its current form, and one is a little older form from an operator called the estate of George H. Coates. But the same information is provided there, and I've used these 2 forms because someone in one of our meetings submitted to us a stack of documents that included all sorts of information on these specific wells, including production information. But this is an example of the information that's available on every well drilled in the state of Texas. So I think we can add to recommendation 2, if you want, the GPS coordinates in addition to the abstract name and number. That would be the appropriate place to do that. Would that be okay?
Yes, so we'll just take a vote on recommendation 1 then.
Without that amendment this time.
Correct.
Yeah.
What page are you on, sir?
Say again?
What page are you on? What page you on?
We're not on the report now. We're on documents that are submitted for recommendations.
So we're no longer looking at this,
That's correct. We're no longer looking at the body of the report. What we're looking at, ladies and gentlemen, is each member of the commission was asked to submit in writing prior to the meeting today written recommendations that they wanted us to take up and consider to be added at the end of the report. And that's the part of this meeting that we're now in. And so everyone that has a recommendation has submitted in writing to us. It's not something that you have in front of you right now, but it's something that all the commission members have. And it would not yet be in the report, but it will. These things will ultimately make their way into the final report to the extent they're approved. Any additional discussion or concerning my recommendation number 1? Then I'll call for a vote. All those in favor of this recommendation, please. Well, let me ask you this. For members of the staffs that are designated and not appointed, do you want to vote on these specific recommendations, or do you want to have this vote roll call so that we can get a yes, no, present, not voting, or absent? What is the will of the staff people who are here? And does anyone intend on these recommendations to vote present but not voting? Other than yes. Mr. Bland?
Yes.
That's what you intend to do? Well, I think we need to make a tally of that. That's my suggestion. Okay. So I'm going to call for a roll call vote on recommendation number 1. The clerk, please call the roll.
Mr. Brune?
Yes.
Mr. Bach?
Yes.
Mr. Burton?
Yes.
Mr. Ramos?
Yes.
Mr. Bazan?
Yes.
Mr. Canales?
Yes.
Miss Allison? Mr. Van Halen?
Yes.
Mr. Cisneros?
Yes.
Mr. Barragan? Miss Aston? Present. Mr. Wolf?
Present.
Mr. O'Neill? Mr. Blanton?
Present.
There are no nay votes, therefore the recommendation will be included. Item 2, as we just discussed, I've already read. The suggestion is to add, in addition to oil companies prospectively furnishing survey name and GLO abstract number, that we also insert GPS coordinates.
Yes, sir.
Then I would suggest that on the 1, 2, 3rd line, well, let's see here, respectively. I'll do no rest furnish. On the 3rd line, after the first word name, insert a comma, delete and insert D, General Land Office abstract number from Railroad Commission Form W1, and after that parenthetical, insert a comma and the GPS coordinates from Railroad Commission Form W1, and then it would continue for each well. And I would accept that as an amendment to the recommendation. So it's been moved. Is there a second to the recommendation 2 as amended?
Second.
Further discussion? This was, we did get public testimony from the Texas Oil and Gas Association concerning number 1. Did not ask them specifically about number 2. That's something I thought of later. But I think if they can furnish, if we can add the data that's required by number 1, that there's no reason they can't add the data prospectively that's required by recommendation 2. Any further discussion?
Is, the GPS coordinates are always on the W1?
They are now.
Okay.
They would not be for older wells, and that's why I think this reads prospectively. And actually, both recommendation 1 and 2 are prospectively. Doesn't require anyone to go back and change what's already been reported. Older wells would not have GPS coordinates. Companies like drillinginfo.com will go back to older wells and assign the GPS coordinates, but it's been my experience that they're not always correct. And it can be off by more than 1,000 feet. And I did try to question drillinginfo.com about that one time, and they wouldn't talk to me. So, but I think prospectively, all operators now will use GPS system and report. With that, if there's no further discussion, we'll take a roll call vote on recommendation number 2.
Mr. Chairman?
Yes, sir.
Just a small point for the benefit of the audience. All of this work is intended to clearly show the descendant families that the well locations are now very, very scientifically identified. And in the old body of work that exists within the files of the Railroad Commission, if you were, for instance, to take and expand the sample that you provided from Frontier Surveying and the Cabeza Oil and Gas Company, if you were to expand this particular charter now, the Railroad Commission has a mapping feature that can be accessed by the internet where you can blow up and enlarge this particular map. And for the sake of knowledge, of awareness, on the upper left-hand corner of an expanded map, there's a number that always designates the land grant. So, as you expand the knowledge and then bring it down to current science and GPS coordinates, there's a lot of information available to the public that identifies essentially most, if not all, of the wells that have been drilled, for instance, in Stark County since 1928. So, and there is a legend at the bottom of most of all those charts, the expanded charts, that indicate where a well was abandoned, plugged, whether it's water injection, oil and gas, and so there's a lot of information that's available to the descendant families if they want to know, what wells have been drilled through the history of drilling operations in South Texas. That's the only comment I wanted to make, Mr. Chairman.
Thank you. Any further comments before we take a roll call vote? Therefore, please call the roll.
Mr. Burton,
Yes.
Mr. Bach,
Aye.
Mr. Burton,
Yes.
Mr. Ramos, Mr. Bazan,
Yes.
Mr. Canales,
Yes.
Ms. Allison, Mr. Runhal,
Yes.
Mr. Cisneros,
Yes.
Mr. Barragon,
Present.
Ms. Aston, Mr. Wolf,
Present.
Mr. Blanton.
Present.
Thank you. That recommendation then will be part of the report to the legislature. I'm going to skip over to item 4, recommendation 4, because I think it'd be a little less controversial perhaps, and recommendation 3 first. And it reads that the legislature amend Texas Civil Practice and Remedies Code, section 64.091, receiver for mineral interest owned by non-resident, that should be or absentee. 64.092, receiver for contingent mineral interest in minerals. And 64.903, receiver for royalty interest owned by non-resident or absentee to 1, require the applicant for a receivership to furnish the comptroller with a certified copy of any judgment granting a receivership, and 2, provide that all payments to the clerks of court resulting from any such receiverships are subject to the unclaimed mineral proceeds reporting requirements of the Texas Property Code. It occurred to me that in our investigation of the litigation in Starr County that it's really impossible for the comptroller to know that these receivership proceedings are out there without sending someone to 254 county courthouses around the state and checking filings of the district clerk's dockets, which would be a burden. So my suggestion is that in order to help the comptroller audit these receivership proceedings and make sure that at the appropriate time, money does get turned over to the state of Texas and doesn't sit in the county bank accounts forever, that there be reporting to the comptroller concerning these receivership proceedings. And I don't have copies of the receivership statutes for you, but the titles obviously indicate what they're about. Discussion concerning that, question or comments?
Chairman, how many amendments do you have at the present time?
I'm sorry, say again, sir?
How many amendments is there added to the recommendation?
How many recommendations? Oh, we have quite a few to go through. I don't know the numbers, at least a half a dozen or more, maybe 10. Okay.
Does this mean that all the ones that currently are in receivership are going to be reported as well?
I wasn't specific about that as recommendation. Most statutes, this would require a statutory change to these civil practice and remedies code sections. Most statutes are effective beginning with cases pending either at the time of the adoption of the statute or September 1 following the passage of the statute of that particular legislative session. So that's probably the way it would be another prospective type requirement.
Well, it just seems to me that there, just by those 2 cases that we saw from Starr County, there could be hundreds of millions of dollars out there. And I think somehow we need to try to get those funds put into the general fund.
Perhaps do the receivership and start
So you would like for just to, I'm not sure we can go back and require the county authorities to report on receiverships that have occurred in the past. Any of the lawyers on the staff, on the commission, have any thoughts about that? I think, so do you have a suggestion on modification of this recommendation? I assume most people will like this idea.
Mr. Chairman, I think what we're really saying is that we would like the county, the district clerk to report any receiverships, is that correct?
Well, I had put in this recommendation, I put the burden to amend the statute to require the applicant to submit a certified copy.
Yes, sir. But the only problem I see there is that if they've already been filed, then I guess you could require them to do that, but I think the district clerk probably would be the logical source.
The money's paid to the clerk of the court, so they hold it in the registry.
Right.
That's what the way the statute reads.
Okay, well, my point is, the applicant, I don't know if you can force the applicant, who's already filed over several years to do this, but that's mine.
But perhaps we can modify this to say that the clerks of court are required to report receivership judgments that have been entered from some date to the present.
And that would cover any recommendations in our system, basically.
Yes.
1986, according to Ms. Fowler.
What about if, and we're talking about the clerks of the court in the individual counties.
Yes.
You know, we all understand how that goes in terms of their workload already and things like that, but I would say, what if requested by an applicant? If requested by an applicant, the clerk then, which I think the clerk has a duty to do that anyways. I mean, I think that it's all public record, and if an applicant went and asked for the information, the clerk would have to do it.
Well, my thought was that something needs to be furnished to the comptroller's office, to the unclaimed mineral proceeds section, so that they can at some point in time follow up and see if there's a judgment, see if money's been actually paid to, and there should be money paid. There would be no reason to have a receivership proceeding, at least in the current environment with the increased oil and gas activities we're seeing more and more receivership proceedings filed. My discussions with operators is they typically do it when they have people they identify as mineral owners, not necessarily royalty owners, but mineral owners who have executive rights, and they want to make sure that they have 100% of the minerals leased. So we say we have a 5 or 10% mineral owner whose location cannot be found. They want to drill that property, but they don't want a 10% net profits interest partner out there. So they file a receivership proceeding. They prove to the court that the efforts they went to find the true owner, the current owner of the mineral interest, they can't do it. If we can't get a lease on the property, it'll impede mineral development. The court grants a receivership, but there's going to be a lease signed by a receiver. There's going to be a bonus paid to the clerk of the court, and then to the extent the property is productive as a result of that, there will be royalties paid per the royalty interest in the lease that the receiver signed to the clerk of the court. And that's how I understand it works. If someone has a different understanding, please speak up. So we have the possibility that money is just accumulating in
different counties.
different counties around the state, and there's no, the comptroller doesn't know about it. So what I'm trying to suggest is an amendment to statutes that would put the burden on, first, at least the person asking for the receivership, who has an interest in making sure they comply with the statute, to report to the comptroller, so that it gets on the comptroller's radar, and then they can include it in their audit process. I guess what we need to figure out is how we sweep or capture past receiverships that have occurred over time, where money is going to be sitting in
Would the district clerk have a record keeping
They should
of
have.
that? They should.
Mr. Chairman, in regard to that, then how would the Starr County incident have been dealt with under your amendment here?
Well, if we didn't know about those proceedings, then we would not have found that money. The comptroller would have found that. But of course, those proceedings were old, and they were just sitting there. They were dormant cases. I guess the receivership doesn't technically end; it just sits there forever.
The only thing I think we need to do is go back retrospectively to a certain date. I mean, I know we can't go back 50 years or so, but I think at least until the Getty Agreement in '86 would be a compromise and require those records to be recorded.
Then let me suggest the addition of a sentence. I'll just sort of paraphrase it here off the top of my head. For receiverships filed prior to the effective date of any legislation adopted as a result of this recommendation, that the clerks of court of all counties in the state of Texas report in the form prescribed by the comptroller prior receivership proceedings beginning January 1, file beginning January 1, 1986 to the present. How about that? Does that change help satisfy the concerns? And I'll accept that as an amendment to the recommendation. And with that change, that is my motion. Do I hear a second?
Second.
Further discussion concerning that recommendation? Then we'll call the roll, please.
Mr. Broom?
Yes?
Mr. Bach?
Aye.
Mr. Burton?
Yes.
Mr. Ramos? Mr. Bazan?
Yes.
Mr. Canales? Ms. Allison? Mr. Rangel?
Yes.
Mr. Cisneros?
Yes.
Mr. Barragán?
Present.
Ms. Aston? Mr. Wolf? Mr. Blanton?
Present.
I have one more recommendation, number 3. I'll read it for the benefit of the public. That the legislature provide by statute a 25-year limitations period during which an owner may file claims for mineral proceeds paid to the comptroller, after which period the proceeds will escheat to the state free of any claims by the owner. The purpose of that recommendation is one of the requests that Representative Guion made to us when he spoke to us at our second meeting, which was to determine or find a way to prevent the unclaimed mineral proceeds fund from accumulating over time. And that's exactly what it's been doing. There will be more money paid in year and year out than will be paid out from the mineral proceeds that are currently being reported to the comptroller. I've used the 25-year period because that is the longest statute of limitations period involving Texas land titles. There is a 3-year statute, a 5-year statute, a 10-year statute, and a 25-year statute, and the 25 being obviously the longest. It's the accumulation of the money in the unclaimed mineral proceeds fund is a continuing liability of the state to the true owners. Over time, the prospect that the owners will come forward and make a claim becomes less and less likely. So my view is that at some point in time, people need to make a claim on the fund. Otherwise, it should no longer be a contingent liability of the state of Texas, and the money should be retained by the state. And that's my recommendation. Excuse me, can I have order in the room, please? Thank you. So that's my recommendation, and I'll entertain a second.
I have a few questions, Mr. Broom. When are you proposing that it become effective?
Not till after the legislature adopted the statute.
So-
Be prospective only.
Be what, sorry?
It'll be prospective only.
Okay.
In other words, it would not be retroactive. It would not take effect until 25 years after the legislature adopted the change. That's what I have. So we have 25 years for people to come forward for all claims in the past and all claims made, up to this point in time.
Mr. Chair,
Yes.
if I may, just a quick note. The comptroller's office has received claims, as you probably know, that are pretty old, and beyond 30 years. I think we have paid out claims that have come in, just FYI kind of stuff. In addition, I think this would put Texas in a very unique category in terms of unclaimed property and putting a statute of limitations on the unclaimed property. I think other states have tried this in the past, and it's very unpopular, and it ends up where they had to go back and kind of repeal that provision. So I'm just kind of letting the committee know that, and so that's all I have.
Well, if no one wants to second it, then the motion will fail for lack of a second. Any further discussion concerning that matter?
Mr. Chair, I understand, I think where you're coming from. You're looking to improve the process. I'm just not sure right now is the time to start closing doors while we're discussing these types of issues.
Good point, brother.
But maybe in the future, we could look at that.
Okay, well, if there's no second to the motion, then it fails, and we'll move on.
Mr. Chairman,
Yes, Mr. Cisneros.
as a little bit of a footnote to the collection of monies or the retention of monies in the comptroller's office, regardless of when the claims could be made or not. One thing that has been brought up, again as a possibility, in order to benefit the state of Texas, could it be considered that the period that the holders retain the money could be reduced from a 3-year period to, let's say, a 1-year period, so that the monies held by the holders could be deposited quickly into the comptroller's office for, for the use and distribution into the general welfare fund. I think that would be a great benefit to the state of Texas if we could consider that also as a proposed amendment to the current provisions, state provisions.
Is that part of the recommendations that you all submitted?
I did not, sir, but I'd be certainly willing to amend my submission, and I do have a document in my files that I created back during the 82nd legislative session that spoke to that.
Okay, so do you want to make a formal recommendation?
Yes, sir, I do.
Go ahead.
I'd like to suggest that the commission include in its report an amendment to the time that the holders of unclaimed mineral proceeds be changed from a 3-year holding period to a 1-year holding period by holders.
That's a recommendation from Mr. Cisneros. Is there a second?
Just how does that administratively impact the companies to do that? And how long has that been the current policy or procedures for 3-year holding?
Okay, 3 years, I think it's been since 86. It was in 86 when that was implemented, or 87. And 3 years is very standard across the board, across property types. One of the big advantages, I think, of having the 3-year is that the company is in a better position to have the information on hand and get in touch and seek out. There are requirements for them to reach out during that period to contact these people, and they're in really the best position to do that. So keep that in mind, as you think about this. 3 years is pretty standard and allows them an opportunity to reach out and try and find these folks.
The 3 years also is designed to require the reporting within a traditional standard 4-year statute of limitations for general statute of limitations. That was one of the reasons they went to 3 years. Also, bear in mind that after they begin reporting on the 3rd year of holding mineral proceeds, they then report every year after that and pay the money in. So it's not 3 years for one owner and then another 3 years and another 3 years. It's after 3 years they start every year reporting and paying in to the state of Texas. So, yes, it would be increasing the administrative burden on the reporters. They do have the closest connection to the property because they're actually operating on the property and have production on the property, and they're in a better position than the comptroller staff to try to locate the true owners, and have no reason not to.
Mr. Chairman, to further discussion, the state of Texas and its oil industry has been very, very aggressively active, certainly of late. And my goodness, if a holder of an oil company cannot find the true owner of a leasehold, rights to royalties, that money really, at first glance, belongs to the state of Texas. And then further to that, whoever might be able to step up and claim some of that money. I think it would be, again, just a great benefit to the state of Texas to have it within its coffers, to use the money to be used in the general revenue fund to, again, be a benefit to the state of Texas, and then respectively to any of the claimants that might come up. I hope that at some point in time in the future, there will be serious consideration given to that change of that holding period. So that's all I have.
Okay, you made a recommendation. Again, I asked, is there a second to that recommendation?
I would ask, if they're on an annual budget and they're going through their auditing and, all the processes and procedures that go with operating on an annual budget, how does that impact, if they have to turn over monies to the comptroller within a one-year period, how would that impact their one-year budget? I'm not sure if I'm being articulate on that.
Well, I think it would increase the administrative burden somewhat and this would require, I think, a statutory amendment to the reporting requirements.
Mr. Cisneros, I'd be open to maybe 18 months.
But probably ought to be on an annual basis, just calendar year time.
Well, they're on a calendar year budget. I'm just saying from within a company, how does that impact them to have to turn over money so fast within their budget year? You understand what I'm saying?
Yes. I mean, there are requirements for them to pay the royalty owners within a certain period of time after initial production, unless they can't find them. That's usually like 90 or 120 days from first production.
So 1 year could be reasonable. If 120 days, if they have to turn over the monies with 120 days, then a 1 year period could be reasonable, maybe. Okay, so second motion.
Any further discussion concerning the motion? Yes, sir.
I just wondered if we're helping tie the hands of reporting here, where the information won't get processed as it would have gotten processed in a longer period.
So you're saying that oil company reporting companies may not go to as much trouble to find the true owners as if they've got to turn the proceeds over immediately? I'm just asking the question. That may be a result. Further discussion or comments concerning the motion? The motion then for a recommendation has been made and seconded. Please call the roll on that motion.
Mr. Broom?
No.
Mr. Bach?
No.
Mr. Burton?
No.
Mr. Ramos? Mr. Kazan?
Yay.
Mr. Canales? Ms. Allison? Mr. Runhal?
No.
Mr. Cisneros?
Yes.
Mr. Barragon?
Present.
Ms. Aston? Mr. Wolf?
Present.
Mr. Blanton?
Present?
What is the tally, please?
That would be 6 nay votes, 2 aye votes, and 5 present not voting.
Therefore, that recommendation recommendation does not pass. However, Mr. Cisneros, you're welcome to, would you like to have that added as a statement from you at the end of the report as a recommendation that was made but not?
Yes, I would, Mr. Chairman.
We will do that.
Thank you.
What I'd like to do now, I suggest we take up the recommendations from Mr. Bazan and Mr. Canales, dated 12/19/14, which has been submitted, and I suggest I turn the initial discussion over to the members that are offering recommendations, and there are 6 on 2 pages in your packet. So, Mr. Bazan, do you want to lead off the discussion?
I'll let my colleague, Commissioner Canales, start.
Should we read them one at a time so the audience has the benefit of?
Absolutely, yes.
I'll read the number 1. Comptroller should enhance transparency in unclaimed mineral proceeds accounting. The revenue from unclaimed property is deposited in a general revenue fund account and ultimately used for general revenue fund purposes. The movement and expenditure of the revenues creates deep feelings of mistrust, especially from many within the Tejano population who believe they may have legitimate claim to the unclaimed mineral proceeds. To promote transparency in government, the unclaimed mineral proceeds from areas within the original Spanish and Mexican land grants should be held in a separate account from other unclaimed mineral proceeds. The comptroller should take appropriate action to achieve this result as needed. That is recommendation number 1. You may have the floor, sir, to discuss.
I'd like to thank those who that I had the opportunity to speak with on this issue. There's a lot of people, a lot of passion behind this. I think this is a reasonable recommendation. It can be done within the comptroller's office according to our previous meeting. And would like to make a motion.
That is your motion, and is there a second?
I just have a second.
Okay, that's what I'm saying.
Yeah, I think one of the big problems is that we don't have a real handle on the figure of the amounts of monies that are involved. I mean, like I stated at the last meeting, it ranges anywhere from hundreds of millions to billions. And unfortunately, it'll be very difficult to go back and try to retrieve this information from past records. But prospectively, we can change that so that we can get a firm handle on the amount of monies involved. And just because it's a separate account does not mean it's not going to be, we're not asking, at least in my opinion, we're not asking that these monies be exempt from the general fund. We just want them to be accounted for separately, because the state of Texas does say that they are good for it, you know, and they vouch for any monies that are deposited in the general fund. So it doesn't have to be a negative line item for the legislature when it looks at this fund, because it's still available for them to use. It's just going to be accounted for separately. Those are my only comments. Thank you.
Mr. Chair?
Mr. Lynn.
Sorry, just a quick comment. That language that you use in your recommendations, I think that's good language, given the period that we're in. You know, comptroller can do so, or the legislature by statute, if necessary, kind of language, I think is pretty good. Just in case we cross over that account threshold and get into creation of a fund, which creates, you know, some area that would require some legislative activity. So
What is your suggestion then?
I think we should add, well, I don't know if it has to be done by rule, but
I think, you know, the language that you use, Mr. Chair, for your recommendations
Yeah.
would be very appropriate.
yeah, that would be fine, I think.
By comptrollers, you know.
The comptroller by rule if possible, and the legislature by statute if necessary.
Yes,
Inserting that somewhere in the appropriate, in your text.
just on the final sentence, if we could amend the final sentence with that language.
I have a comment about this recommendation. I was studying Mr. Farias's supplement number 7, which was submitted before this meeting and which you have. I'm reading from the first paragraph, he first says, quote, mineral proceeds from unclaimed wells authorized in state district court receivership hearings whose owners have never been found, I refer to as type 2 funds. These funds are not to be confused with what I refer to as type 1 mineral funds. This is the trust fund managed by the Unclaimed Property Division of the State Comptroller's Office. In reality, these unclaimed minerals are royalty check payments previously being paid to the title holders who had contracts with oil and gas companies but abandoned their payments. These come back to the state with a name, in the most cases designating the name of the title holder / contractee. These are not the funds claimed by the heirs of the Spanish and Mexican land grants approved by declaratory judgment. These categories of adjudicated heirs, except for a handful of persons, have absolutely no legal claim to these monies. I couldn't agree more with that statement by Mr. Farias, which is, I think, something that we try to emphasize in the report. So what we're talking about is two things. We're talking about the money that's been paid to the comptroller to date, which primarily, probably 99.9% would be what Mr. Farias would call type 1 funds, which he says the heirs have no claim to. What I think the group that's here is interested in is what he refers to as these type 2 funds, which are money from unclaimed wells. These are the wells that this body does not believe exist. So we're talking about segregating accounts at the comptroller's office from unclaimed wells, and there's no way to identify what that could possibly be. So I don't see that this serves any purpose from a practical standpoint and will accomplish what is any good purpose. That's my comment, for what it's worth. Any additional discussion?
Mr. Chairman, I'm going to vote for this because I've said in the past, I do not think that the legislature will set up a separate fund to do this, but this is a compromise, and that's where I am.
More discussion. The motion's been made and seconded for recommendation number 1 as amended. Please call the roll.
Mr. Byrne?
No?
Mr. Bach?
Aye.
Mr. Burton?
Yes.
Mr. Ramos?
No.
Mr. Bazan?
Aye.
Mr. Canales? Ms. Allison? Mr. Runhell?
Yes.
Mr. Cisneros?
Yes.
Mr. Barragon?
Present.
Ms. Aston? Mr. Wolf?
Present.
Mr. Blanton?
Present.
And what is the tally, please?
6 aye votes, 2 no votes, and 5 present not voting.
The recommendation carries and will be made to the legislature. Recommendation 2 from Mr. Bazan and Mr. Canales, I'll read it.
Before we get into that, Mr. Chair, I'd like to make a point of personal privilege to give background to this recommendation. I've asked Mr. John Falcone to be here, and I'd like him to help introduce this item for me. So this is germane to my recommendation.
We had not scheduled, invited for public testimony today because I felt that we needed to conclude our work on this report to the legislature by this meeting. However, if there is no objection from any member of the commission, I certainly have no objection to receiving testimony from Mr. Falcone.
Mr. Chairman, members of the commission, thank you for your time and work on this project. You have the appreciation of many. Realizing that the process of your commission is in its final stages, I'm going to be as brief as I can, as expedient as I can, so I'll confine my comments to about 15, maybe 20 minutes at the most. In the interest of all concerned, it is important that we arrive at a conclusion the state needs to establish, and forgive me, I'm not privileged to your information, so if you find anything redundant, please bear with me, because I'm going to get to some very specifics that I think you need to hear. That the state establish a means to hear and properly adjudicate the legitimate complaints aired in your forums. You know, the constitutional infractions of some of these allegations are so immense, and the evidence so clear that I see no way except for the state to fulfill its constitutional obligations. Now, at this point, it is evident the state has received a considerable amount of testimony indicting the state for crimes against Hispanic settlers whose lands were confiscated by deadly force and other atrocities, cases in which no constitutional protection and no justice was extended by the state. The Tejano victims and their families, had there been justice, the unclaimed mineral debate today might take on a little different course. In searching for causes for these injustices, I furnished your commission exhibits which clearly establish unofficial racial prejudice against Spanish and Mexican settlers by the state of Texas and its institutions. I doubt that anybody would disagree that any land transfer was perpetrated by murder cannot possibly be legal. Yet in many cases of adverse possession were based on just those circumstances. The most glaring indictment of all of the state policy that was the one that would punish Spanish and Mexican settlers for remaining neutral during the Revolution. And this punishment included confiscation of land and titles and documents filed in the Texas archives today clearly exhibit that. So now at this point in the process, we're attempting to finalize recommendations to the legislature. It's imperative, I think, that some key factors be reinforced for your consideration to communicate to the Texas legislature the need for, first, to provide amends for damages caused by the state's official policies of racial discrimination against landowners. And the whole idea behind this effort is to encourage development of an efficient way to adjudicate these claims. So I'm going to ask you to weigh these documents that I'm going to present to you today, together with what I presented April 25th and September 12th, based on your perception, make a determination of whether it's a worthy concern to the state. The only caution it offers is the volume of information I furnished is minuscule. It's a drop in the bucket by comparison to what's out there, what actually exists in the archives and other official documents. Second, because I've heard considerable opinion by members of the commission that the state should not have to pay amends for damages, which resulted from the state's racial policies, I'm going to brief you on damages caused by official directives from several of its governors. I believe it's important to bear down on the state's official institutional framework that caused these crimes and damages. This will help, I believe, establish the need for legislation that will facilitate resolution of these crimes. The reason I offer documented evidence of these governors is because they were the state's chief executives. Their orders resulted in murders and other atrocities committed against Tejanos. Those were institutional acts. They were performed by the chief executive of the state under the official auspices and laws and policies of the state. So please keep in mind that it's vitally important to closely examine the difference between individual acts of savagery and institutional acts of savagery. And if we haven't already, I hope we can accomplish that today. Only as a refresher, and only for your convenience reference, I've reattached enclosure 1, which I've previously furnished to you. It will help you clearly see as we put this together with some of the things that have been discovered since then. It will help you clearly see the institutional framework of the racial crimes perpetrated by the state and its institutions, and why I'm driving home the point of need for proper adjudication of complaints. And I commend Mr. Bach. Mr. Bach, you have a kudos from me, sir, for your recommendation. I think it's brilliant. I think it offers a broad range of coverage, which I think would be very good, very just. If you would at this time, just take a look and put them on your binders. I just want you to run and see that it's connected to Governor Peter Bell and the state legislature in the 1840s, and we talked about that before. The intent of the article, of course, was to punish Texas Mexican descents who had sided with General Santa Anna who would remain neutral. We talked about remaining neutral. The act, which I think did a great deal of damage, perhaps the most, which was created a climate of free-for-all town lands in any criminal way conceivable. And the debate in the legislature at that time exhibited this point, which you can find included in the document. Again, to be specific, it was Article 8 of the Texas Constitution, which at that time allowed for confiscation of land if the owner had left or refused to participate in the Texas Revolution. Now, folks, again, just common sense, deductive reasoning. You're 50 or 60 or 70 years old, and this battle is taking place right in your yard, in your front yard. You're going to go out there and join the fray. A company of dragoons come by, I've mentioned that before, and ask to water their horses in your pond. You're going to run out with a shotgun and run them off? We know the answer to that question. Or just any excuse to take the land. Now, when considering all of the above, if you look at enclosure 2, far more atrocious almost a century later, in 1915, which means this racial prejudice spanned over 2 centuries. Texas Governor James E. Ferguson sent Texas Ranger Captain Henry Ransom to the lower Rio Grande Valley to lead a pacification campaign. Ransom was in charge of an assassination squad. They conducted a scorched earth campaign of annihilation against both guiltiness and Mexican. Now, when you merge these official acts together, the outcome clearly frames the institutional side of this official and unconstitutional Texas policy against Hispanics. Previously in enclosure 6, my April 25th testimony, I quoted Governor Ferguson when he was asked by an investigator. He retorted that this troubled mess, and that was the resistance of Spanish American settlers from Canada land seas, had gone on long enough, and he, Governor Ferguson, had appointed Henry Ransom a known criminal. This man already had killed somebody. He killed an attorney in the court trial because he didn't agree with this guy's presentation. Ferguson appointed this man with a felon as special ranger to take care of it. And he, Ferguson, didn't care. Ransom had to kill all the Hispanics in the valley. Ransom did. Governor Ferguson with pardon. Now, 2 years later, Ferguson was indicted on 9 charges, including misappropriation of public funds, and the House of Representatives prepared 21 charges. The Senate convicted him of 10, removed him as governor. Here's 2 governors and the legislature who instituted and carried out policies of racial discrimination against Hispanic landowners. As a result, didn't seize their land. So, folks, are we beginning to see the institutional liability that's clearly reaching critical mass among a good portion of your population? I hope I'm getting through. Now, Ferguson, of course, received justice for his crime, but what about the Tanos who lost their lands, their lives, and their entire family fortunes? Crimes that were perpetrated by director and chief executive of the state. With the affirmation of these circumstances, in layman terms, I ask myself, what court would not hold the state of Texas accountable for these crimes? You know, today, all the Tano men and women and children who buried these massacres paid the ultimate price. Now, the subsequent generations of these victims are yet paying the price of this enormous deprivation, which was officially instituted, sanctioned, and ordered by 2 governors of the state. Does Texas still believe that justice should not be served to Hispanics? That was prevalent back then. Is that still an ongoing state policy? No, I don't think so. But the state created the problem. Is the state had it to fix? Yes. We're going to talk about that in just a moment. But now the big question remains, does Texas want to resolve these allegations? And how do we convey the necessary sense of urgency to the state? And I'm not conveying the necessary sense of urgency to you. I've heard inferences from some of you that the state should not have to provide amends for damages for these losses. So I ask here now, why not? You know, it doesn't seem that long ago when members of this body were proclaiming the vast solvency of the state when questioned about the method of accounting for unemployment royalties. There was an adamant response where it's the effect that regardless of any amount claimed, Texas guarantees its full faith and credit its ability to pay its liabilities. Seemingly, has all the money in the world necessary to do this. So why are we hearing opinions from this body that the state should not be held accountable to amend the damages it superimposed on towns through its racially discriminatory policies? You know, one of the things that I think is most important in this case, take a look, because Anglo families who filed for adverse possession to Tejano land during that same area are still benefiting from those land values today. But yet, when it comes to justice for crimes against Hispanics that ended up as illegal land transfers during the same area, seemingly there is a tendency to call those cases ancient and not within the statute of limitations. So in fact, the argument from the establishment appears to be good for the Anglos, not good for the Hispanics. Good for one, but not good for the other. If the directives of two governors, Peter Bell, 1840, James Ferguson, 1915, does not alert jurist attention to the glaring racial institutional prejudice by which crimes were perpetrated for purposes of confiscating lands from the defense of Tejanos who were victimized by the state's racial policies. If that doesn't raise a flag about the state's institutional liability, responsibility, then it's very likely the outcomes will be driven by legal proceedings in each case instead of a far less expensive claim system. Gosh, I hope I'm getting through the premise. It makes sense to establish a claims or special court method by which these cases can be resolved with finality and closed forever. Once and for all, I seriously doubt the state will escape this indictment. The documented evidence that I've researched and seen is far too extensive, and information technology far too easy. I think I said it right when I said expensive too. Most incriminating. When you look at most any direction of treatment of Hispanics, the official statements of public officials during that era are clearly documented. When entered into the state's historical files, it's clear that the folks who made these statements had no idea that someday in the future, information technology would expose them for what they were. Criminals, no less. As an example, ladies and gentlemen, I truly appreciate the support. What I'm delivering today is so important. I don't want the Commissioner to miss one item. Please, I beg you to hold your applause, and thank you so much for your support. So, during the course of 2 centuries, the official history of Texas became replete with cases of prejudicial treatment against Hispanics, which were criminal in every aspect. And so we hopefully might grant the urgency for finding solutions for these settlements, these disputes. Texas, folks, in my opinion, going back to all the experiences, all the cases that I handled as an Inspector General federal system, Texas cannot stand a test of its integrity for the constitutional support that it provided Hispanics during that era. It won't make it. There is no government on this earth that should treat any race of its constituents with the horrible and criminal manner in which the state treats Hispanics. You can find it in virtually any direction in history. Look, now, I'm going to introduce just a few items, and I'm going to get off this podium, unless you have questions for me, to just show you a clear pattern that there was an institutional objective first to dispossess Tejanos of the lands. And then as that was so, there remained a very clear pattern of exploitation of the race by any means conceivable. Labor, cheap labor, slave labor. But it extended far beyond exploitation. Clearly you see how fraud of school funds allocated for educating Hispanic children in the 20s and 30s were arbitrarily taken from the Hispanic school allocation redistributed to Anglo schools. During the school terms, the districts would muster every Hispanic child to report to the state, a complete census of Mexican scholastics, that's what they're called, for which they would receive $17.50 for the education of Mexican children. Then because the Mexican property taxes, the tax base, did not cover the cost of operating Mexican schools because they were separated. They would take the state funds allocated to Hispanic schools and distribute them to the Anglo schools. In effect, first there's a movement to dispossess the funds of the land, and then the state education funds are confiscated and allocated to Anglo schools because they didn't have enough property tax volume to support the Mexican schools. Hispanic children were sent to the cotton fields. They chopped and picked cotton when it was harvested. The Mexican schools were closed early so that the children could be released to go pick and chop cotton. There's an enclosure 4 and 5. You'll find a whole bunch of those. I simply want to give you a taste of what the state will ever have to face if there is a massive effort to go back and look at that. So folks, from my experience, I say now let's face reality. The Texas government was and still is very much alive today as it was then. Very much within the form it existed when it perpetrated the sort of crime we're discussing. Very much within the scope of its written history and certainly within the scope of its documented legislative records of service. So how can Texas escape its indictment of crimes against humanity? The overwhelming evidence, well documented within the state's own archives, I don't see a way except for Texas to face reality. It acted criminally must make amends for the damages of its crimes. And when any government treats a race of people, constituents, as despicable and disgusting, as horrible as Texas treated Hispanics, sooner or later, that government is going to pay the price. And folks, I'm afraid that the day of reckoning for Texas is here.
Yes, sir.
So thus, in summary, to strike at the heart of the problem, I beg you to look at how you can convey to the state documents, information, material that indicts Texas for its racial discrimination policies that produced the contested land transfers that were aired during your forums. For that reason, I respectfully recommend that you consider adding recommendations. And what I've added, you'll find them probably in the last enclosure, is probably redundant to what you've already done. So I don't even want to get into them. They're there if you want. Take a look at them if they help. But most important, and I truly again commend Mr. Bach, because if the system Mr. Bach proposes can relate to all the claims, all types of claims, not just unclaimed royalties, but anywhere where there's been a constitutional infraction, where somebody's land was taken away illegally, the impact of that is still happening today. Folks, in closing, I simply again extend my sincere gratitude for the opportunity to share my thoughts on the subject of the state making amends for damages. I think you're at a very important juncture in the history of this great state, and I hope we can repair the damage done by some of our previous administrations so that we might acknowledge our responsibility in those matters and continue being a great state in the minds of all our constituents. Thank you so much.
Questions or comments for Mr. Falcone?
Mr. Falcone, thank you so much for being here today, and thank you for that information, because a lot of people don't know, and for that to educate us like that is priceless and very compelling. Thank you so
Thanks.
much.
You're welcome. Mr. Chairman, if I may, one more comment, and it's off the cuff. I did a lot of study on the dormancy period. We talked about it in the past. It went down from 7 years to 3. Because of the way the dormancy period is calculated and because of the data that goes into what the dormancy period protects for the oil companies, bringing this thing down to 1 year wouldn't hurt anything. Very simply, it goes year to year. The year that is found, that's the year it can be reported. So that's just an opinion.
Thank you.
You're welcome.
Excuse me, sir, we were only taking testimony from Mr. Falcone at this time.
I'm sorry, I flew from Chicago, and when I got on the plane, I understood there was gonna be public testimony, and I understand that it got changed. But I plead with you for the dignity of my ancestors and my generation and future generations, that I be allowed to give you a 10-minute statement, please.
Is there any objection from any member of the commission to allowing this witness to give us a 10-minute statement? There being none, you may proceed, sir.
Thank you, sir. Thank you very much. I first would like to dedicate this statement that I am about to read in honor of a man that could not be here today. A man who taught me and our families all about our history and genealogy. A man who served his country proudly in the United States of America for many years as a military man and as a hero, not only to his family.
Excuse me, can you please tell us who you are for the record?
Oh, I'm sorry. I'm sorry. My name is Jose Sierra Jr., and this is Joshua Sierra. Thank you. The man's name that I was referring to was Fidencio Gonzalez. He is from El Paso, Texas, and he is why I am here today, and I want to thank him. I'll proceed. I promise to keep it as short as possible. Thank you. I would like to thank this committee as well as everyone in attendance for the opportunity to speak here today. Let's imagine that this is not 2014, but the year is 1848. You took ownership of your land under a mandate from the King of Spain, and you were there for 20 to 25 years when all of a sudden you witnessed Mexico's independence from Spain and the growing migration of Americanos in Texas. And in a few short years, the newly migrated Americanos fighting for free Texas from Mexico and Texas becomes the Republic of Texas, which was only a brief necessity in order to join the United States of America. This was the Americanos' ultimate goal. Now further imagine yourselves owners and residents of a piece of land in a country you know nothing about. You are told that you still own the land that the Spanish king granted you, and that you will be protected by the Constitution of the United States of America. But in reality, you are as remote from the law as anyone can be. You are now an American citizen, but without any rights whatsoever. If those who came to inform you gave you a document, you may not even be able to read it, either in English or in Spanish. There are no lawyers to advise you, no police protection, and the courts are definitely against you before the trial even begins. You are as close to the law as you are to the moon. Such a scenario might have been, the beginning of the uprooting of our ancestors from their lands. I am not a lawyer, but taking something which isn't yours, such as land or the ownership of the mineral rights being spoken here about today, is stealing, and this is a crime that was condoned by the federal, state, and local governments in the United States of America. I hear the voices of these victims saying to us, where is the justice? Where is the compensation for our losses? When will we be heard? I believe that this may be their last chance to be heard, and they are the ones I speak here for today. I recently read somewhere, to mourn loved ones is honorable, to remember them is holy. We remember them each day, each and every one that was victimized by a federal, state, or local government. Both the federal government and the state of Texas looked the other way and allowed many crimes to be committed, such as this gentleman spoke of. On citizens, they were obligated to, by law, to protect. They refused to give our ancestors the most basic rights, the rights of all U.S. citizens. But that was the past, and today we must put our emotions away and deal with the cold, hard facts. Facts. You are lawyers, you deal with facts. Facts logic, and reason are the things that all humanity understands. It is the common language of the seekers of justice and equality. Fact number 1, most land and mineral rights were taken away from rightful owners without cause and under duress. The man spoke to it very eloquently. We know their land was illegally transferred to second and third parties under very suspicious circumstances, as well as some lands that were abandoned due to threats as well as murder. Yes, murder. It was land leased, and part of the agreement was to be able to pay yearly taxes for that land. It was inevitable that the land would be up for sale for unpaid back taxes, and the landowners would not even be aware of it. So the land would be purchased for pennies by the same person who had paid the taxes as part of the lease agreements. There was an astounding lack of respect or concern for these owners by the conspiratorial corruptions that were allowed in the institutional philosophy. This was the initial crime. Fact number 2, decades later, an attempt of remuneration of these lands was made by the U.S. federal government. It devised a flawed plan by which money would be given to the sovereign country of Mexico so that it could be dispersed as payments to all of those Mexicans for Texas land that had been usurped. Even though many of these victims lived in the United States, America gave Mexico $149 million or more so that Mexico would be responsible in paying for everyone that had their land swindled from them in American courts and those that fled from their land during the lawless years of Texas. Not one individual gave their land willingly, so America thought that this would be how those victims would be repaid for their land. I personally have never heard of anyone who has received any money from such a fund. In 1984, when a group of land grant heirs took their plight to the Supreme Court of the United States to have the United States of America intercede and implore Mexico to give the money to the rightfully intended, and once again, the court did not do the right things. They merely said that they did not have a right to tell a sovereign foreign government what to do. The only question I have is, why did the U.S. government give Mexico the money? Shouldn't America have paid our ancestors directly and made sure that these new American citizens were justly reimbursed for their losses? I'm sorry. Fact number 3, it would appear that the American government never made an attempt to repair the injustice, which was, to say the least, a blatant act of prejudice in the extreme. To this day, there have been no law or advocacy for these individuals, either public or private. The wound caused by the injustices borne by our ancestors is still not healed. It is indeed sad to think that these victims were never deemed worthy of governmental protection on any level at any time in the past history. Shame on them. However, when we speak of shame, there is enough to throw about in any direction. I do appeal to my brothers and sisters here today who participate in my plight to hear me. The shame will also include us if we don't pick up the banner which our fathers carried and their fathers before them. It is our struggle for this cause. We can no longer afford the luxury to stand as a single twig of our family tree, which can be snapped easily with 2 fingers. It would serve us better to bind our family trees into a giant mass, which could not be bent or broken easily. This simply means that it will take all of our efforts and single-minded purpose to bring this cause to a desired resolution. Do I have all the answers? No, I do not. But if we join together and we can bind together, we may be able to get the best results. We have come to a crossroads and may never get another opportunity such as this venture again. We must make the best of our efforts and fight for our common cause. The door has been kicked open for us. Now we need to make our choice. Are we in the arena for the duration of the fight? And are we ready to pick up the load and carry to the right destinations? One thought, one purpose, one goal. This is called unity. If we do not see this through and speak for our ancestors, then truly it is a shame on us. It is only right that we ask the question, didn't Texas have the vision to set aside enough funds for the day of reckoning? Did Mexico give the money back to the United States government? Where did the money go? I only ask this question because many of us would have had different lives if our ancestors would have had the opportunity to keep the only thing they had, their land and their mineral rights, which is the reason we're here today. Some of you may say that this injustice is too ancient and too complex. It's too large and can't or shouldn't be dealt with. You would rather it would go away. But it isn't complicated at all. To find the descendants and the heirs and pay them what they deserve. That's how you end this. For decades, money was paid to Texas for mineral rights. Again, I ask, where did all that money go? It certainly never came to us, as it should have. I have heard statements regarding how much money is in the coffers from royalties, but to be honest, it does not add up. Texas is known around the world as having made oil millionaires. So where are all the royalties from all these oil wells that were dug on our lands? Once again, the injustice continues in Texas. Oil companies were given a free pass and unpaid taxes for oil taken from the lands and mandated that the royalties would be forgiven forever prior to 1964. Even going back to 1964 to present day, I again ask you, where did all the money go? Our ancestors became U.S. citizens and dealt with two separate countries, Mexico and the United States of America. Neither of these countries deemed the victimized worthy of our advocacy or justice. I suggest to you, two countries told the same lie. To my brothers and sisters here today, I would like to leave you with something to think about, recalling a famous quote from President Ronald Reagan. If not us, then who? If not now, then when? I thank you for your time and your patience. We are frustrated and very, very difficult to express our grief for the tragedy that has befallen our people in your state of Texas. I'll answer any questions or take any comments if you have any to speak.
Questions or comments for the witness? Thank you, sir.
You're welcome.
If you have your comments in writing, that would be helpful for Allison to put that into the minutes.
I would appreciate it, sir. Thank you, Con.
Thank you.
And thank you again for letting me speak.
Well, I have a request for a recess, a recess. Let's take a 15-minute recess.